questions now if folks have them. There's obviously a ton more we could be talking about today. This is just a thumbnail sketch. And there's a lot written out there about this issue. If you're interested, I can point people towards resources, and I'm happy to answer questions.
Out of curiosity, what's the likelihood that jurisdictions will pass laws supporting the right to counsel? I mean, how's the support for it? Is there a lot of public opposition, or is this mentioned, or is this like an uncontested issue?
There is, it's a good question. The main opposition when you talk about passing legislation is money. The legislators are not convinced yet that it's cheaper to provide counsel than it is to not. And so that's what a big part of the pilots is about, to try to convince that. There is some opposition that comes from the private bar who think that this will take away their clients. Now, I will just frankly admit I don't understand that argument, because these clients are not being taken, they're not going to be taken by anyone because they don't have any money, and their cases often don't involve any money. If you win a termination of parental rights case, you can't do that on contingency because there's nothing to get. It's whether the person gets their kids or not. So these clients that we're seeing unrepresented are not ones we think that the bar is looking to represent right now. But that is a concern in some areas, that some state bars are worried about competition.
I noticed on the list that there didn't seem to be a lot of federal legislation. Like I saw immigration, but that was about it. But is there any like TPRs? Is there any movement on that?
So I don't intend to defend the federal government because they have a lot of work to do in this area, and in fact, we're actually writing a report now about how they're not complying with international obligations that would relate to the right to counsel. But termination of parental rights is really a state issue, and so when it comes to, they certainly could be providing more money, but they would not be the ones to provide the right to counsel per se. There are a few statutes that provide a right to counsel. If your home is taken, if you are in, what is it called? Forfeiture. If the government is seeking to take property that it thinks was used in the commission of an offense, if it's your primary residence, you have a right to counsel under federal law. And there are a couple other very narrow circumstances like that that involve either federal courts or a federal issue. But mostly this issue is at the state level. On the other hand, immigration is their concern, and they do not provide a right to counsel. In fact, the statute says that they will never pay for it. Currently, they say at no cost to the government. That's something that we're looking to change.
Mark Noker, Brooklyn Law School. I'm wondering how much of your advocacy turns on the right or the thing being taken away, and how much of it turns on the person, whether they're sympathetic or vulnerable?
You mean in terms of like the litigation that we bring?
Sure. Like for example, in immigration, there's a proposal to give mentally disabled immigrants counsel, but
Yes.
not others, even though the constitutional arguments may be just as strong, if not stronger, for others. So I was wondering your thoughts.
So there are actually two different things to untangle on that. Part of it is, there are many people, myself included, who think that the courts are not ready to bite a big chunk of the apple right now, and that the way to start is to give them a narrower class of people, still class, so it's not a case-by-case approach, but it's a defined set of people that's smaller than the entire group. So like for instance in New York, they proposed legislation that would have provided a right to counsel only for seniors in eviction foreclosure, because they thought this is a smaller group, it's a sympathetic group, we could start there. Not because they wanted, that was their goal in the end, but that was where they figured they could get a toehold into the argument. So that, there's a big debate nationally about the big apple versus the smaller piece, and some people are worried, what if we establish this, then they might not be willing to go any further. If a court talks about how disabled litigants are so imperiled in immigration, then they might say, well, not like regular, unimpaired. Then it's sort of like they use that argument against the rest of the group, and then when you try to go back in for the rest of the group, they say, we just told you that these folks are capable of doing it themselves. So there are concerns about that happening. As far as the sympathetic plaintiff, you all learn that your case is only as good often as the court likes your client, and unfortunately, there are plenty of people who deserve and need counsel who we cannot make an argument for because the court will never give it to them. In a parent case where the parent has, done something terrible to one of their children, and then there's an issue about their other child, the court's gonna use that other one against them, even if it's not relevant at all to the analysis about this child. Even if it's totally irrelevant, it will get used by them, it will be used in the media. So we have to pick our cases very carefully in that respect. I don't know if you want me to,
Let's do
One-
one more.
one last
and then
one?
we gotta
Sure.
move on.
Thank you. Excuse me if I missed this, but in regards to the international guidelines, is it guidelines or policy, and has the US ratified it?
That's an excellent question. The US has ratified several treaties, but whether or not they're self-executing is I think is the question. I think, I'm not an international law expert, but my understanding is that a lot of these treaties would need Congress to actually implement legislation to put them into effect. So you can't really walk into a courtroom and say, the ICCPR says I have a right to counsel in a housing case, because you're not gonna get, even if, well, the courts don't like international law anyway, but even if they did, you need, my understanding is that Congress still needs to do more work before those will become enforceable rights. I would also be remiss if I didn't mention where the rights to counsel exist in DC as a last thing. Abuse and neglect, termination, guardianship, mental health commitment, and adult protective proceedings, and what they call in DC sexual psychopath proceedings. It's a lovely term. Those are where you have a right. There are some other areas where the court can appoint, but doesn't necessarily have to. So, thank you. I'll be here the rest of the day. I'll be happy to take questions later as well.